Gloria Brubeck for sticking with the struggle and staying warm with the struggle and continuing and not giving up. So we're going to turn it over to Gloria, and we're going to start the press conference now. And welcome to S.H.A.P.E Community Center, okay?
Thank you. Okay, so as I was saying, we've had some very unusual events happening this week. Unfortunately, the District Attorney's Office has decided that they do not want the facts to come out concerning the use of the death penalty in Harris County and how in Texas, and how it is unconstitutional because innocent people have been and will continue to be executed. This is a violation of the 8th Amendment to the United States Constitution, which prohibits cruel and unusual punishment. Because the District Attorney's Office filed a motion with the Court of Criminal Appeals, the hearing is temporarily shut down for 15 days until both sides can submit their facts to the Court of Criminal Appeals. We are hopeful that the hearing will be allowed to continue. In the meantime, we are here to condemn what the Harris County DA's office has done. We are very disappointed in Pat Lycos. We thought that perhaps the good old boy system was no longer in place in Harris County, but it appears that it is, because she had not only told her assistant DAs to stand mute during the hearing, but now because of her motion it has been shut down. There's a statement that the attorneys made that they are hopeful that the CCA will look at the merits of the case and allow it to continue. And we agree with that. We have a couple of people here today that are going to speak. Is this channel 39? All right.
Yay!
All right. We'll give you just a second to get set up.
Thank you.
Speaking today will be Lee Greenwood Rollins, whose son Joseph Nichols was executed on March 7th, 2007, I believe. And she will explain to you the tricks that the Harris County DA's office did to execute 2 men, including her son, when 1 shot killed a man. And yet, that 1 shot was fired by 2 people. Also speaking is Jerry Shakur with the Texas Death Penalty Abolition Movement. And then Clarence Brandley, who is living proof of why this motion on the constitutionality of the death penalty should have been heard and should have been granted by Judge Fine. With us, we also have Human Hedayati, who is with the Witness to Innocence, a national organization of death row exonerees, and Reginald Gordon, who's with Operation OG1, who fights to keep people out of prison or to keep people from going back to prison. We have Veronica Kelly-Young, who was one of the people that actually got the struggle for Clarence Brandley going back in the 1980s, and is, along with Deloitte and others, responsible for Clarence Brandley being with us here today. Okay. I'm going to ask, huh? Okay, so I'm going to start with Lee and ask you to come say a few words.
Please tell us once again who you are, ma'am.
Good morning. My name is Lee Greenwood Rollins. I'm the mother of Joseph Nichols, who was executed in March of 2007, wrongfully for a crime he did not commit. The hearing that's going on, that has been halted at this time, is very much needed. In Joseph's case, the victim was Claude Schaefer. He was shot with 1 bullet. There was a co-defendant in that case, Willie Ray Williams, who stated when he was arrested that he had shot Mr. Schaefer and that Joseph had left the scene and was not there. In his hearing or trial, it was stated by the DA, who was, I think, Bob Burdett at that time, that there was no doubt that Mr. Williams had fired the shot and that was the truth and that was all it was to it. Willie Ray Williams was sent to death row. When Joseph was tried, his first trial, he was tried under the law of parties, and the jury hung up on the punishment phase and said that they could not execute a man nor sent him to prison for life for not being the shooter. The DA's office decided to try Joseph a second time. In his second trial, they changed or altered that truth that was stated in Willie Williams' trial and said that indeed this time Joseph had fired the fatal shot. Now mind you, there was only one bullet that Mr. Williams had confessed to and that Joseph was not present when this went on. But the DA's office was allowed to retry him, changing that so-called truth and use it to gain a conviction and a death sentence for Joseph Nichols. Consequently, Joseph was kept on death row for 25 years and then executed in 2007. With this hearing that we have been privy to and has been halted, that would possibly stop people, innocent people, from being executed. As Joseph, in Joseph's case and his execution, I feel sure, as most people feel, that there have been many innocent persons executed, especially in the state of Texas, since Harris County is the most flagrant violator of using the death penalty in any case that they think they can get a conviction. So saying that and briefly shutting it down is unconstitutional to the rest of us that are now here living in Harris County under the DA system that we have. And as Gloria has said, we expected better things from the present DA than we have had in the past. And this hearing could possibly, and I believe would possibly, stop some of the wrongful executions and flagrant miscarriages of justice and any little trickery that comes out of the DA's office to obtain conviction and consequently send persons to death row.
And, oh my gosh, can you walk up there? I believe I can put you. There might be. Okay, the next speaker is Jerry Shakur with the Texas Death Penalty Abolition Movement.
To go on meting out death sentences when it is unconstitutional that the black, brown, and poor people brought before them do not sit before a jury of their peers. They don't have competent legal representation. Brother Clarence here, along with 10 others, was snatched off the gurney by the collective will and effort and struggle of people right here in this building and from many diverse communities who abhorred the injustice that contrived evidence that never existed to sentence an innocent man. Now, Harris County first kept quiet because their positions are indefensible. The wrong they do to sentence the poor is indefensible, so they kept quiet. And now have suspended the process altogether to keep us ignorant of the truth, of the wrong, immoral, and illegal things they do to sentence the poor, black, brown, and white people of this community. We deplore what Pat Likas has done. We will continue to struggle, fight, and raise the truth. It is too often said, and it is too true, that it is better to be guilty and rich than poor and innocent. That's much of what this process was bringing forward. We will continue our struggle. The only reason that Brother Clarence is alive with us today is because of the collective will of the people that justice occurred. The way that Texas uses the death penalty is unconstitutional.
Okay, before I introduce Clarence, I want to make a point. The DA has said that Mr. Green should not be raising these issues because he has not yet been convicted or sentenced to death. I want to address that because one of the things that was going to be proven in this motion was that the habeas corpus process does not work in Texas and clemency is virtually non-existent. So the two things that are supposed to be safeguards once you find yourself convicted and you're innocent don't really happen. So it was perfectly appropriate for this to come out before he was convicted. The other thing is that the evidence being used against Mr. Green, eyewitness identification, informants or jailhouse snitches, and possibly faulty forensics regarding fingerprints, which all three of these things have been very key to the 260 exonerations in this country. These are the three types of evidence that were going to be used against him. And as his attorney said, the claim by Mr. Green is based on a constitutional theory never before examined by the Texas courts and derives from the mounting evidence demonstrating that the kind of evidence against Mr. Green, eyewitness identification, testimony by paid informants, and fingerprint comparison is often inaccurate and leads to conviction of the innocent. And with that, I would like to introduce the man who the sheriffs pointed a finger at back in 1980 and said, "You're the," and used the N-word. No, somebody's going to hang for this. "You're the N-word and you're elected." Well, thank heavens Clarence is with us today. Clarence Brandley.
Yes, my name is Clarence Brandley, and I'm here today and in support to these gentlemen and people that are here today, that are trying to get a hearing to determine whether or not the capital punishment in the state of Texas is constitutional. Why not have a hearing before someone is convicted? Because once someone is convicted, it takes many and many years. And then if you actually carry out that execution and you find out later that they're innocent, then how can you bring them back? I'm so glad that I had a group of individuals, a lot of them here today, that fought for me. Because if I was executed, they could bring me back today. And why are they such in a hurry to kill someone when it's been shown over all of the studies that it's cheaper to keep someone in prison than it is to execute them? And I've always tried to stress to people that just because someone is arrested and indicted does not mean that they are guilty. And you'll be surprised, not only just here in the state of Texas, but throughout the United States. People ought to wake up and look at all of the people that have been charged with capital punishment through the United States that have been released. Now, suppose all those people have been executed. You can't bring them back to life. And why? And I really admire Judge Fine, because it takes a real man or woman to stand up and admit when something wrong is going on. And if you're a career politician, you don't just do that. You are more concerned about your political career than in doing that which is right. It never ceases to amaze me that every time someone stands and takes a stand for that which is wrong, and they think that it's wrong, and they believe in their heart that it's wrong, they meet opposition. So I'm praying that the Code of Criminal Appeal will allow Judge Fine to continue with this hearing. It is so essential, and I think the whole world is looking at the state of Texas right now. Why are you in such a hurry to delay this process, when this process should be determined before someone is convicted? And I'm going to continue to fight and lend my support to these people who are struggling for this cause.
Okay, we can open up for questions. Clarence is one of 138 innocent people who have been exonerated off death row. 12 of those exonerations were in the state of Texas. Up on the sign over here it says innocent but almost executed. Clarence Brandley Ricardo Adapigueta, Ernest Willis, Michael Toney, Anthony Graves, and there's more, Munir D., Vernon McManus, Randall Dale Adams, Jim Skelton. So this is living proof of why Texas needs to examine what they're doing with capital punishment. So, any questions?
Where do you go from here? What's your next step, or what can you do?
Well, two things. Hopefully, the hearing will be allowed to continue, and we'll be involved in trying to cause more attention to be focused on that. And whether or not the hearing continues or not, those of us in the abolition movement, in Witness to Innocence, S.H.A.P.E Center, we're all going to continue fighting the death penalty until it is done away with, because we know it is on the way out. Harris County actually went 2 years without sending anybody to death row. Because of the question of innocence, people's hearts and minds are changing, and they're looking at the death penalty and questioning it. So we're going to continue to force the issue and force people to develop more questions until we do away with it. The majority of states that have the death penalty, and it's 35 states, don't use it. The death penalty is used in the South, the former Confederate states, which shows the connection between lynchings that used to take place and the legal lynchings which go on in Huntsville now. So we're going to continue fighting.
Gloria, more than the good old boy network mentality that you claim is happening with the DA's office, do you think that Judge Lycos is the fact that she used to be a cop and a judge, and that has no bearing?
I'm sure it plays into it, because Harris County has a history of cops, the judges, the court-appointed lawyers. I mean, they've all been part of this good old boy system. Pat Lycos came and talked to a number of us in a group called the Coalition for Justice and promised there was going to be a new day. And unfortunately, this has proven that she has gone back on her word, and it's not a new day when she's not allowing this hearing to happen.
So you don't think there are other forces that keep her from
Oh yeah, I mean, it's obviously a political issue. I don't think that it's just Pat Lycos, but she's the head DA now. She did not have to tell the attorneys to stand mute. She did not have to file that motion to the CCA. She could have allowed the facts to come out, and she chose not to. So it's a good old boy and good old gal system going on in the DA's office now.
What is the Court of Criminal Appeals telling you guys about whether this thing will eventually...
Well, they've given each side 15 days. By my calculations, that's December 22nd. I am not sure how, once the papers are turned in, how long it will take them to make a ruling. But this, this is an example of what's been happening in the state of Texas when, for Governor Perry, stonewalling the Texas Forensic Science Commission when they were trying to bring out the truth on Todd Willingham's wrongful execution. So this is a continuation of stuff. I wish some reporters could find out if Governor Perry ever even read the forensic report that he was presented before Todd Willingham was executed. He had it on his desk. Who knows if he read it. Bush, it's just come out that Claude Jones, who was executed in December of 2000 and was Bush's last execution, he was worried about the vote for president and supposedly never even saw the information that one piece of hair Claude Jones wanted to have tested. He denied a stay. Claude Jones was executed, and today we're finding out the only evidence that connected him to that murder was faulty. Anybody else? Okay, and en español tenemos un. You wanna? Okay, all right. Anybody else? Okay, thank you all for coming, and I hope that you will help point out the fact that the DA is hiding the truth from the people of Harris County. Thank you.